very much for me.
Come on, everybody.
What shall I render to Jehovah?
Hey.
For he has done so very much.
Right, hello, good morning and welcome to the show. This is Good Morning Ghana live on Metro TV. It's a Thursday, the 24th day of June 2021. By His grace, we are live and we're here with yet another edition of the show. Our gratitude will go to Most High God for the privilege of being alive and, of course, the opportunity of having another conversation around the top stories making the rounds here in our dear Republic. I'll let you into our panel for the morning's conversation shortly. Let's take a look at the front pages of our newspapers. Daily Graphic. All set. 3 days to census night. Ghana shortlists vendors for nuclear power plant. Resist temptation to spend more. Adongo advises government. Consider retirement homes for teachers. Kwame Pianim tells NAT. Ghanaian Times. COVID-19 mitigating measures. Government spends 896.3 million Ghana cedis on free water. Cecilia Dapa. New national standardized test for pupils takes off November. Education Minister. VIP rally support for effective implementation of Land Act. Daily Guide. Coup plotters in quotes plan to kill Nana. Aegis slams NDC's power contract. COVID-19 vaccines effective against Delta variant. Baumia chases land barons. Ashanti Minister defends former MP. The New Crusading Guide. $170 million judgment debt. Prosecute signatories to GPGC power purchase agreement for causing financial loss to the state. Doma East MP. Nitaki Obli family disowns Bezalel Zola, says he's not part of the royal family. Consolidate existing data to update Ghana's nautical chart. Transport Minister to stakeholders. Magdan supports 1,500 widows on his 50th birthday. Shiashi Lorry Station land under threat. The Insight. Kwekwaza, he wants AG 2 others held for $170 million judgment debt against state. TUSAC threatens strike. Panic over new Delta strain of coronavirus. Disease outbreaks increase with deforestation. New study finds. The Daily Statesman. We can get it right. Baumia champions technology-driven land administration. Law to fight LGBTQI+ in the offing. Bagging hints. Very much waiting to be buried on July 3. Daily Post. You failed to properly defend Ghana in $170 million judgment debt. Don't blame NDC. Kofi Bua to Godfrey Dami. You won't be Attorney General forever. Jenapo tells Godfrey Dami a $170 million judgment debt. $170 million judgment debt. Hold AG, 2 foreign law firms accountable. Kwekwaza. Business and Financial Times. Attempts to frustrate accountability won't work. Bank of Ghana governor calls for support to retrieve 19 billion Ghana cedis from shareholders of collapsed firms. About 50,000 firms risk losing legal status this month. Registrar General. Domestic investors account for 13% of Ghana Stock Exchange activities for Q1. Fan Milk PLC increases investment, opens new office complex. PPP framework, an opportunity in managing COVID-19 pandemic. And NAT plans to establish commercial bank. That's about it for the front pages. We'll be back shortly.
In Ghana and in Africa, there is only one place to look to get that luxurious design and decor for your offices and homes. Visit Jamila Home. We give you the climax of luxury wherever you find yourself. Presidential and executive office furniture, living room sets, dining set, stunning mirrors, adorable wallpapers, lovely king and queen size beds, valuable antiques and antique goods, beautiful chandeliers and more. Into the bargain, we provide caring customer service, prompt delivery service, skilled and artistic full house design and decor services, and free decor ideas for your space. Our products and service is unparalleled, boasting of top-tier clients all over the globe. Jamila Home, home of first-class quality furniture, beautiful chandeliers, and antiques.
The average human body mass should have at least 60% water for optimal performance in any physical or mental exercise. We can help you maintain it naturally. X Natural Mineral Water. Simply natural.
Right, welcome back to the show. If you just joined us, this is Good Morning Ghana live on Metro TV. With me on the show this morning is a legal practitioner who's also the National Communications Officer of the NBC. Sammy Jemfi, good morning, Sammy.
Good morning, Doctor.
How are you doing?
By God's grace, we're managing.
Okay.
Yourself?
Oh, I'm good, I'm good. Grace abounds. From your answer, it appears that you're really living the good life.
Not at all.
Because anytime I ask you, you give me a particular answer.
Oh,
today you've departed from that answer.
No. The Lord has been gracious and
which
kind.
Means that the 4 more is 4 more to do more for you.
No. This 4 more is 4 more of more suffering. 4 more of more hardships.
You don't look like somebody who's suffering.
Are you sure?
Oh, yes.
Some appearances are deceptive. My appearances are deceptive. The pocket is dry.
Also with me on the show is Daddy Abdulmalik Kwekubaku, Father of the Year.
Mischief.
Belated Happy Father's Day.
Thank you. Same to you.
He's not yet a
yes.
father.
Soon.
He's still selecting.
He will do it soon.
He's still selecting. Sabi, I hear you are spoiled for choice. You require prayer and fasting to make the right choice.
That's propaganda.
Do people ask you why you're still not married?
Oh, not really.
Or people don't ask you?
I'm not sure.
Or they assume that you're married?
Oh, they don't. They don't assume. I'm not sure I've exceeded the permissible time range for that yet.
You're not sure?
I'm still within that time range.
But it gives you stability.
I
hope that you are not being mentored by Abdul Malik.
by God's grace, it will happen
this
soon.
year.
I'm not too sure about this year.
You are not too sure?
Not too sure
about this year.
But very soon.
Is it because you've not made a choice?
Oh, no. It's not about that. But
so you've made a choice?
Doc, this is not a personality, but this is Good Morning Ghana.
Good morning,
Ghana.
Ghana.
To put me
Good morning, Ghana. Says good morning to all issues.
We are still looking at one
studying.
or two things. Yes, one or two things.
One
yes.
or two women.
Yeah. Oh no, not one or two. We are just getting prepared, because that's a journey of no return.
Have you made a choice? Are you dating?
Largely.
Are you dating?
I'm sure they are watching.
Oh, come on.
they are watching.
Are you dating? Are you dating?
Randy,
that's not something I can speak to publicly.
Okay, you want to keep that privately?
Yeah, privately. Because if you say you're not dating, then it raises questions. If you say you're dating,
have you started?
But I'm not searching.
Have you started counseling?
Counseling.
Yeah.
Oh yeah.
You started counseling.
Not counseling in the proper sense of counseling, but at least going to church, learning from people who have the experience and getting yourself prepared for that journey. Okay. I mean, like I told you, very soon it will happen.
Soon. But not this year.
I don't think so.
Okay. All right. Okay.
It just took me unawares.
I'm sure that the bloggers and sites have two headlines already. Oh yes. That's why the answers have been cagey and evasive.
Not at all. I've been very direct.
You've been very direct.
Yes.
So can you tell us her name?
Oh no.
You won't disclose her name?
No. Not a suspect.
Is she also a lawyer?
Oh no.
Not at all.
Not at all.
Which profession?
That's confidential.
This man is a suspect.
Savage Jeffy. Ojaba was Father's Day.
Oh.
Now VL is over.
Yes. Oh, see you. Yes.
Now we are free.
Yes. That's right. Terribly free.
We are free for at least another 2 months.
Yeah. This is the longer one.
Yeah, this is the long
vacation.
Yes. We're free till I think 6 September. Sammy? If lawyers who are pro-MPP have not scandalized the court, and it's only pro-NDC lawyers who have scandalized the court, what is the problem with the CJ petitioning the General Legal Council over their conduct?
Thank you very much, Doc, and let me say good morning to Mr. Bako officially, and to our cherished viewers. You see, we don't have to engage in equalization or rationalization when it comes to professional conduct of lawyers. Okay. But it is important that the rules are applied in a fair and just manner and in a way that engenders confidence in the system, in a way that shows that no particular group of lawyers are being targeted or are being hounded, but that people who are filing these complaints against lawyers for misconduct have a genuine basis for doing so. Okay, so I'm sure you are referring to the press conference that was addressed by our General Secretary on Dr. Ayene's invitation. I mean, we are not saying that NDC lawyers, or we don't even have NDC lawyers, but lawyers who identify with the NDC have scandalized the courts. And MPP lawyers have also scandalized the court, and so that is okay. That's not what we are saying. We are saying
I
that...
asked the question
we are saying that
a part of your statement suggests that the CJ has targeted.
Yes.
And you give names of about 4 lawyers.
Yes, and we are saying that... We are saying so not because the lawyers who identify with us are guilty of the complaints that have been lodged against them.
Right.
So that has to be made clear.
Right.
In our opinion, none of those complaints that have been filed by the Chief Justice against lawyers who identify with the NDC, like the one filed against David Annan, lawyer Maleba, Honorable Roxanne Dafie-Makpo, and all that, none of those complaints are justified.
But I'm
That's our position.
I'm told that the first 2 you mentioned, David Annan and Amaliba, rendered apologies.
Well, settlements and all that. You see, there was an inquiry, and at the end of the inquiry, the decision of the disciplinary committee was that render an apology. So you choose whether to render that apology or whether to challenge, or whether to challenge it.
Where do you challenge that?
You go to the High Court.
Okay.
Okay, even though there are justices of the Supreme Court on that disciplinary committee, if you want to appeal against their decision, you go to the High Court. And that is one misnomer that we can have a conversation about.
The disciplinary committee consists of
Supreme Court judges? Yes.
But wouldn't that...
Supreme Court judges. It's a misnomer.
Yeah,
that is why...
Wouldn't that then play into being judges in their own courts? Because if a person is supposed to have criticized or scandalized the Supreme Court for his views on judgments of the Supreme Court, and the person is reported to a body, which also comprises
of some of them, not all of them, then it raises the... And that is why you recall that in the Lawyer Sosu's case, Javier Sosu, he went to the High Court to set it aside, and the High Court judge set the decision of the disciplinary committee aside. And Lawyer Samukujeto, who is a member of the disciplinary committee, went to town that the judge had no capacity to do so because those who took the decision included justices of the Supreme Court. So
but they were not sitting as the Supreme Court.
No, they were sitting with powers of the High Court, and the law says you challenge their decisions there. And so in our opinion, we don't think that those complaints were justified. But this is the point. If what we are being made to understand is the case that Dr. Ayine has breached some rules of professional conduct of lawyers, which we disagree with, but assuming without admitting that that is the case, for which reason the Chief Justice has lodged this complaint against him. And bear in mind that in all the cases I cited, the complainant was the Chief Justice himself, who is the chairman of the General Legal Council. We are saying that there are other lawyers who identify with the NPP who have committed clear breaches of the rules. They didn't express an opinion which can be deemed as an attack on the judiciary or the Supreme Court. But they breach the rules, for example. I give you, and I cite this example reluctantly, okay, but just to demonstrate the point I'm making. If you look at the new rules of professional conduct for lawyers, it is very clear that when a matter is pending before a court of competent jurisdiction and you are a lawyer on record, you are not allowed any longer to comment on that matter.
But all of you were commenting during the...
But we were not on record.
Presidential.
Mareta
was on record.
He was not on record. It was only... That is why on our side, we, the lead counsel, Mr. Chachuchikata, was only announcing lawyer Tony later. And Mareta, Brew, Apiaopon, and Dr. Ayine were leading the communication, with some of us myself, Eduji,
so they
and
were
others.
not on
So,
record.
so they were not on record. They were not on record. But lawyer Opon was on record. Lawyer Frank Davis was on record. They were part of the legal team of Nana Addo Dankwa Akufo-Addo. And they were always announced in court as representing Nana Addo Dankwa Akufo-Addo by the lead counsel, Akoto Ampao. Yet, they were all over the place addressing the media and commenting on that matter. That was a clear breach of the rules of professional conduct of lawyers. Has the Chief Justice cited them for the breach of those rules? Has he sent a complaint to the disciplinary committee of the General Legal Counsel for them to be disciplined? No.
Maybe they were warned in court.
So some are warned.
They were warned in court.
Some are warned, but others are hauled before the disciplinary committee. Because you see, when you are hauled before the disciplinary committee, it is not a small matter. So one of the decisions that can be meted out to you, if you are found liable, includes the listing from the role of lawyers.
Of your license.
Or revocation of your license. So it's a serious matter. So we are saying that if in those cases where the rules were clearly breached by lawyers on the side of the MPP, no actions were taken against them, how much Dr. Ayine, who merely expressed an opinion, a subjective opinion, about his hopes in the independence of the judiciary on the verdict of the Supreme Court, that is post facto, after the decision had been delivered. He goes for an academic exercise organized by the CDD with other lawyers from the MPP present to discuss the impact of these election petitions on our democracy. He's asked a direct question. What is your confidence in the independence of the judiciary in the wake of this judgment? Other lawyers said, we are very confident in the judiciary because the decision went well, it was decided well and all that. He says, no. For me, my hopes in the independence of the judiciary has been dampened because of the way and manner the Supreme Court determined some of the interlocutory applications of the petitioner without due regard for judicial precedents and settled rules and practices. That is all he said. Then, because of this, he's been called before the discipline committee. Doc, is it by force to have confidence in somebody? He's talking about his subjective opinions, his hopes. Last time we were here and this issue came up, Mr. Bako referred to Rule 52 in the Rules of Professional Conduct of Lawyers, which some lawyers had averted his mind to, that could be the reason why the Chief Justice has taken this step. But that rule has to do with you publicizing information, facts, statements about a judicial officer which you know to be false or without due regard for the truth of that statement. So that statement has to be a statement of fact. So for example, if you go out there and you say some judges took bribes in the hearing of this petition, that one is a statement of fact that you should be able to substantiate. If you are unable to substantiate because that statement is false and that statement is about a judicial officer, then Rule 52 kicks in. You can be disciplined as a lawyer. But if I am merely asked a question about my subjective opinion, relative to my confidence in an institution, and I say that because of the way and manner they decided some of the applications, for me, my hopes in their independence has been dampened. What is scandalous about this? What is curious about this? The man was very decent and courteous. We all know Dr. Ayine, respectable lawyer, gentleman par excellence. He never said anything to impugn the integrity of the court. And finally, we have said, as a political party, that we stand with him and we will stand with him till the end and ensure that no injustice is meted out to him. And in our opinion as a political party, we have said that we think that the opinion he expressed was justified. We as a political party share that opinion, and we gave two reasons. We said that, look, yes, justices of the Supreme Court are allowed to depart from their previous decisions. But the practice is that when they are departing from their previous decision, they must indicate the reasons for doing so. You don't do it arbitrarily. In the 2013 election petition decision, Justice Eni Yeboah, Justice of the Supreme Court, as he then was, said that he was disappointed in the Afarijan-led Electoral Commission because they did not assist the Supreme Court to establish the truth in the matter. Why? His beef was that the EC did not file any pink sheets before the court. Bear in mind that Afarijan had actually testified and was cross-examined vigorously. But because he did not file pink sheets, Justice Aniyewa took issues with that and said the court had to rely on duplicate pink sheets filed by the petitioner. So why didn't Afarijan file the original pink sheets and all that? Now we come back this time around in a petition involving John Mahama in 2020. These same issues of production of documents for inspection come up again. And Justice Aniyewa says it is okay for the EC to decide not to produce these same documents without giving any reasons for departing from his previous, as if to say that G. Mensah was not obligated to assist the Supreme Court in establishing the truth like Afarijan was obligated to do according to Justice Aniyewa. So in the face of these seeming inconsistent decisions coming from some of the judges, we think that the opinion the man expressed was constructive, it was justified, and as a political party, we support it. We think that this complaint has no basis. We have appealed to the Chief Justice to withdraw it so that the matter can die a natural death. But if they decide to pursue the matter, we will also pursue it. We are ready for that. And we are going to ensure that, like I said, no injustice is meted out to anybody for expressing their constitutionally guaranteed freedom of expression.
Madam, does our CJ have a weak chin? Should he develop a thicker skin? Or you think that he is upholding the professional standards and should be encouraged to do same?
Well, this might be an unfair question for me to respond to. Yeah, it may be very unfair. I mean, in my candid opinion, though it's a legitimate question that must be interrogated, you know. But perhaps when I finish my analysis, it will point to that.
That's fine.
In that direction. See, first and foremost, and I think Sami himself did a quick clarification. We have no NDC lawyers or MPP lawyers, strictly speaking.
Yes.
We have lawyers who are affiliated or even members
yes.
of these political parties. So those lawyers who are being dragged before the disciplinary committee are being dragged there on basis of what they are professionally. They are lawyers.
You and I can't be dragged there.
Exactly. So they are going there as lawyers. And they've been going there. Randy, second point, Yao Pong, Marita, Apia, and Frank Davis were cautioned in the course of the proceedings of the election petition. That was the first signal. We're talking here of sequence. While when they were cautioned, it was a signal to all others that the court would take serious view of that thing they had been doing to the extent that they were cautioned. That's what it was. So I'm not able to concede that that caution compared to the subsequent actions was discriminatory or selective. It wasn't. It was a preliminary alert given to everybody, all lawyers I mean, connected or unconnected to the issue.
Like a warning?
Yes, and you actually indicated that earlier. So we cannot mix the two. It is subsequent to the caution that was issued to the three, I think there were three or so, that Dr. Yimi's contempt matter came on board. And he was dragged before the court. He purged himself of whatever contempt they alleged he had committed. He even got a former bar president of repute to come and support his case in court, live. Is it Beecham?
Okay, yeah.
Am I right?
Yeah.
Frank Beecham.
Yeah, Frank.
Very senior.
We all saw it. Yeah, very senior and very respected.
Yes, former GD.
And indeed, his presence alone. It's like the Sir John Ayikui Otu thing. It helps. Everybody there, they are all human beings. And that's when I finish, you see the angle about the chin question you asked. So let's please draw the lines of extensions carefully and critically. Dr. Ayini, when he appeared, in a way, clearly to everybody, considered he was wrong. And so asked for forgiveness, quote unquote. He was pegged. I'm even told that it's been expunged from the record, so there's no record. Then don't forget who he is, the former Deputy Attorney General, a top good lawyer. So for that to be raised is in his own interest. Subsequent to that, he appears before a forum, very important forum that I support in principle, in terms of Judicial Review Dialogue Series. That's the title. He makes comments similar or same to what he had made earlier, that same thing before.
And that kind of dialogue is a dialogue with the intent of critiquing judicial decisions.
Exactly.
Right? Okay.
And to help.
So just like the Ria Koto.
I have no problems with that. The principle is good. I support it, and it's not new.
Yes.
It helps our jurisprudence, it improves upon it and everything. No doubt about that.
In fact, it's something that is done at the law school every day.
Yes. And there are journals that publish those things.
Peer reviews.
Yes.
Professional reviews.
Again, the context is not the same as the Supreme Court's proceedings on the election proceeding was. So it's not the same.
Yes.
But you see, and I have no difficulty personally with what he said at that forum, personally. And that's why I even made a case, and that's perhaps where your answer lies, that perhaps the CJ's reaction was an overkill. And that if I were in his shoes, or if I were to have the opportunity to advise, which I know I would never have, is to say that ignore and let's move on. But there are other schools of thought, legal and judicial, who say that if you make the statement he made and link it to lack of independence of the court relative to the decision they arrived at, you are actually questioning the integrity of those who sat on the thing.
Could the answer also not be linked to the question asked?
Yes, but you don't get my point.
Yes,
I'm telling you what a certain school of thought have advanced.
Okay, whether you agree with that or not
is
another
not.
matter. Okay, all right.
Okay, right. But they're making that case that the substantive point is that you are more or less suggesting that the panel, at least, that sat, lacked some independence, which is why they arrived at the decision they arrived at. That's a point some people are making, a logical deduction or an inference and all the rest. I still stood by the point that, look, allow it to flow, and let's move on. But see, Randy, there's something that is worrying, and I've seen his response
to the GLC,
to the Administrative Secretary of the General Legal Council.
Yes.
Very powerful, well written, articulate. This is what I thought he could stand by all the time, even at the Supreme Court.
Sometimes situations demand.
So was it fear?
Maybe it was strategic.
Driven by lack of courage of conviction?
Oh.
Well, so what was it? You see, but that is the point.
Maybe at the time you thought that.
Randy, let me tell you, that is the point I'm making. What are we doing? Here we are, some even made some allusions to the fact that some of the rules and things, maybe a bit, I don't know what word to use so that I don't put words in his mouth. But it's like, you must review, you need to look at it again. Even the composition of the General Legal Council is this Supreme Court. He was going in that drift, and there may be some merit to that. But you see, the point I'm making is this. We're talking about lawyers.
Right.
Learned minds. That's who they are. Trained.
That's what they call themselves.
They are. Yeah. To study law is not a joke.
No, but that's what they call themselves. It doesn't mean that they are more learned than other professionals.
Okay,
yes.
I see your point.
So that's how they refer to themselves, yes. And we are fine with it.
The learned profession.
That's how they call their profession.
But it takes a lot of thinking.
It takes a lot of thinking in journalism as well. It takes a lot of thinking in engineering.
Give up.
It takes a lot of thinking in medicine.
Randy doesn't want to give up. I hear you. You see, my worry is this.
Right.
The NDC statement. And it's the NDC intrusion that has made me a bit uncomfortable with this whole subject matter relative to Dr. Ayine. I thought the NDC's intrusion was unwarranted.
You think they should have stayed off?
Completely. Because the gentleman, Dr. Ayine, was invited in his personal capacity by the CDD as a legal policy expert and a former deputy attorney general. But the invitation they sent to him was that we are assembling legal policy experts. That's the emphasis. And to that extent, you are invited. So he was there in his individual, or he was on Zoom, I suppose, but it was part of the dialogue series in his personal capacity. The NDC intrudes, and Randy, listen to this. This part of their statement. It says, as you may be aware, only a few months ago, some lawyers with NDC leanings, specifically lawyer Ibrahim Amaliba and David Annan, were hauled to the disciplinary committee of the General Legal Council by the Chief Justice in similar fashion and harassed, this is the operative word, harassed for expressing their views on the constitution of the Supreme Court panel that heard the 2020 election petition. Harassed. That's the operative word. This gentleman appeared before the disciplinary committee with oral and written apologies. They orally apologized, added to it a written apology. They put a gun on their head to do that.
Maybe the consequences.
So, Randy, that is the point I'm making. Did they tell the NDC that they were harassed? Is that the suggestion?
That the process of petitioning and being hauled before is considered a form of harassment.
We shouldn't allow lawyers. We shouldn't, who have signed up to this document. This is like their code of conduct.
Yeah.
And it is not one person who sat somewhere and drew it up. We shouldn't allow them to go before those committees and apologize, beg, and then come outside that committee and create the impression they were being harassed. It's wrong. It's inconsistent. It's unprincipled. You are a lawyer. You've committed yourself to this document. You live by the rules. I'm sure there are avenues to challenge sanctions that are imposed on you if you believe those sanctions are not sustainable. He mentioned... yes. That's a mark of courage. Those things, a critical mass of those characters lead to reforms. We cannot allow them to seek refuge in some imaginary fears. Oh yes. Oh yes. When some of us in our profession are dragged to the media commission and the rest, and we think we are right, we insist. And there are cases that some of us have won there. There are some we lost. Even journalists who are dragged before the courts, we were sent to the Court of Appeal for contempt. We insisted we had not committed contempt. They jailed us, but we went. We're not lawyers. These are lawyers. And I'm stressing that for good reasons. And that's why perhaps I had that little argument with you as to how much power, brain power they have. And the stature and the prestige that come with their profession. You can't do that. You can't go to the committee. You don't defend yourself. You go begging. And then you come outside from there and say, I was harassed or I was afraid. I want to keep my license to practice and all. What are you talking about? That's unprincipled. That's cowardly. And I'm not about to accept that. If I were Dr. Ayini, this is a powerful document, response. I will appear, and I believe he may, because I don't know.
It appears that is intent. He's asking them, he's asking them to disregard. But if they think there's a basis for the inquiry, I'm sure he'll make himself available.
I would be happy with that. Let's proceed with the disciplinary matter till the end, its logical conclusion. Others said, look, GBA has intervened and said that let's grant a general amnesty to all lawyers at that point in time. So it was agreed that based on the apologies, written and oral, general amnesty is declared. Okay? Ayini's thing came after the amnesty that was issued. That's perhaps the basis on why the Chief Justice and others might think that, look, in spite of the amnesty granted at the behest of the GBA, based on the written and oral apologies of these lawyers, it appears it's not making an impact. I'm sure that faction that didn't believe in the amnesty may be thinking that we told you so, so bring him back, especially when he makes similar statements and things. They are ignoring the fold, which is where I have a difficulty with their line of thinking. So please, it shouldn't be allowed that these people go there, they go and beg, they are granted amnesty, they come out and say, we were harassed, we feared, we were afraid of the consequences, and then people are giving them support, their party.
Let's just put on record that those persons have not said they were harassed. I've not heard any of them say so.
Yeah, but you see, you're damn right. But it's unfortunate that the party will say this. So then it's suggestive, as if this is the feeling they gave to the party.
Or the party by itself believes that the process they were taking through constitutes harassment.
Then the usage of the word harassment is irresponsible. It's unwarranted.
That's how the party feels. That there's a form of harassment.
Yeah, but you know, and
that the Chief Justice is using that tool to harass and cower lawyers.
But in this case, in contest, if David Annan and Ibrahim Amaliba hadn't told the party their feelings that bordered on harassment, do you think the party would do that?
They can.
On their own?
Yeah.
That's why it makes it irresponsible.
Okay, Doc, I have a few...
That's what makes it irresponsible.
A few rebuttals.
We need to take a break. Okay. We'll be back shortly.
The search for a reliable partner in dealing with your U-turn bus needs has been made easier and convenient with SA Automobile. SA Automobile, formerly U-turn Ghana Limited, has been in the business of offering quality U-turn product and services at competitive rates. At SA Automobile, our team of expert staff, management, engineers, and mechanics professionally deal in the sale of U-turn buses, genuine spare parts, its repairs and maintenance at a highly effective workshop with remarkable speed. We also have available the sale of Camel car batteries, Weichai and Kia spare parts, Zonton coaches and light duty vehicles for everyday movement. Contact us on 020-000-0831 or 054-555-7500. You can also email us info@saautomobilegh.com or visit our website at www.saautomobilegh.com. SA Automobile, the pleasure of doing business with you is all ours.
Football and Nuntin High Sense as sponsor Euro 2020. Edia Maono. Nesa Suntin Ayatiti TV say who? Edia Maono. Hisense Hero 2020 TV Super Promo. Kahuai kwajo brand new Hisense TV and ne form. Pictures ne clear na color ne deep. Sound quality ne so de one it here. Hisense TV so de extra power. About down one access you are. Akona utu sa barefoot. Everything 18th June, Akofim 11th July. Hisense Hero 2020 TV Super Promo. Emma Refisa, Hisense and Emma 5 years warranty. Hisense Hero 2020 TV Super Promo. Ekosu wa Hisense showrooms I want Ghana for Nanina. What you dear Nansenya? Hisense, everyday prices for everyday people. Hisense, official sponsor at the Hero 2020.
Right, welcome back to the show. If you just joined us, this is Good Morning Ghana live on Metro TV. Still with me on the show, I have Sami Jemfi and Abdul Malik Kwekubako. The show is brought to you in kind partnership with X Natural Mineral Water. And Nadia Shifa, happy belated birthday to you. Sami?
Yeah.
Yes.
Look, just a few issues. First of all, I made a point about what appears to be a selective way, of lodging complaints against lawyers who are identified with the NDC by the current Chief Justice. And Mr. Baku says he disagrees with me on that because in the case of Marietta, Frank Davis, Lawyer Paul, they were cautioned by the court. But you see, what he fails to recognize is that the content of those cautions were not the same. The caution given to Marietta and the caution the Supreme Court gave to Lawyer Paul and Frank Davis were not the same. And until you address your mind to the content of those cautions, you'll be equating two different things. Like I told you, Marietta Brewer-Piopong was not a lawyer on record. So the caution to her was not about any breach of the legal profession rules of conduct. It was not about that. It was about a comment she had made about the case outside court at the press briefings, which the court felt was unacceptable. Mm-hmm. So it was not because she breached the legal profession rules of conduct. You went out after a court proceeding, you addressed the media. We think that some of the things you said were unacceptable. You are a former Attorney General, so we are cautioning you, be mindful of some of the things you say. That was it. But in the case of Lawyer Paul and Frank Davis, the caution given to them by the Supreme Court bordered on breaches of the legal profession rules of conduct. That's the point I'm making. Because they were in breach. They were all over the place, passing prejudicial comments and seductive comments, patronizing the court. And like I said, I'm very reluctant, to cite some of these examples. If I read to you some of the things Frank Davis said during those press briefings, you'll be surprised. He virtually predetermined or prejudged the case when he was a lawyer on record. He was not even supposed to comment on the matter in the first place. He didn't only comment, but made serious prejudicial comments. And he was only cautioned. So you see the difference. You cannot equate that of Marietta, the caution given to Marietta, to the two lawyers. So the point I made, that if the issue is about breach of the legal profession rules of conduct, then we should be applying the same standards. If Frank Davis and Lawyer Pong breached the rules and they were giving amnesty, they were cautioned. At least this is the first time Dr. Ayine is alleged to have breached the rules. Why is he not being cautioned like the two MPP inclined or affiliated lawyers were cautioned? That's my point. Because And that takes me to the second issue, the issue about content. I said this the last time and I would want to repeat it. The statement Dr. Yine made, for which reason he was cited for contempt, and he purged himself of that issue, is materially different from the statement he made at the CDD event. So let's not create the impression that, oh, the man says something in the course of the hearing, he was cited for contempt, he came and apologized. Then after the court decision, he was so reckless that he went to an event and repeated virtually the same comment. That was not it. The comment he made, for which reason he was cited for contempt, I won't go into the details, but it had to do with his saying that the court had a predetermined mind to rule against the petitioner. At the CDD event, he didn't say anything about predetermined mind. He didn't say anything, because then, in the case of the contempt, he would have been called upon to prove if he had not purged himself. How do you prove that somebody has a predetermined mind? So looking at the nature of the matter, I think that the legally appropriate thing for him to have done, the legally wise thing, it was not out of cowardice, like some would describe it, for me. But that was, and you see, the rules of contempt are different from the rules that work when one appears before the disciplinary committee of the General Legal Council. So as a lawyer, you need to weigh the two, and your defense can definitely not be the same at those two fora. Taking cognizance of the fact that the issues for which you even appear before the two fora are different. So let's not equate the two. At the CDD events, let me read to you a quotation. And that's for me, because this was the publication, the only publication the General Legal Council attached to the invitation they sent to Dr. Yine. And that publication quotes what Dr. Yine is alleged to have said, for which reason the Chief Justice. This is what he says. Adjudication is a process of accountability. So for me, it is okay to dismiss an application brought by a petitioner for one relief or the other, whether substantive or procedural. But it is another thing to fail to apply the rules of procedure in a manner that enhances the accountability process. And for me, this view is justified. So at the end of the day, the petition actually dampened my hopes with respect to the independence of the judiciary and its ability to hold the Electoral Commission, in particular, accountable in election petitions. This is what he said. It cannot be equated to the statement he made, for which reason he was cited for contempt. And we are saying that this statement is not scandalous. It does not impugn the integrity of the court in any way, because he was talking about his subjective hopes. Neither Dr. Yine nor the NDC can be compelled to increase our hopes or our confidence in the judiciary when we have not been given any basis to do so. You can't force somebody that have hopes in me, have confidence in me, when I don't feel that I have any basis to do so. And because of that, you hold me before for disciplinary action. Now, Mr. Baku says that to some people, this statement, because
there's a school of thought.
There's a school of thought that this statement about the independence or not that undermines the integrity of the judiciary. How?
That to the extent that you say that those things you found inappropriate undermines the independence.
Yeah, I said it.
Then you are ascribing motives.
You see, let me read to you another quotation in the story, and then you see how he framed it. He was very careful. He said, quote, I am sure. Okay, now, I expected the Supreme Court to apply faithfully the rules of procedure. 2, in terms of adducing evidence, prove the petitioner's case, and so on. What we saw was a Supreme Court that was constantly putting hurdles in the way of the petitioner in terms of adducing evidence to prove the petitioner's case. And this one, if you look at his response, he explains, he raises the issue of adverse witness. And the fact that when we sought leave to reopen our case, as in the petitioner, to call the EC chairperson as an adverse witness, the court said no. You can't call her as an adverse witness because per the Black Law Dictionary, an adverse witness, somebody can be an adverse witness only when he has mounted the witness box and his testimony is found to be adverse to the interest of the party who called him, relying on the Black Law Dictionary. As to whether that is correct interpretation of the dictionary is another matter. But then, we told them in court, Lawyer Chachuchi, that this Black Law Dictionary doesn't apply in Ghana. Because our Evidence Act, Section 72, is clear on who an adverse witness is. And that section says that in any civil action, a party or a person whose interest with a party in the case are the same can be called by an opposing party as an adverse witness and cross-examined as though he's an adverse witness. You understand? So if I have an issue with Randy Abbey, host of Good Morning Ghana, and the producer of the show, Aniampofo, has the same interest with Randy Abbey, I can subpoena or call Aniampofo as a witness, knowing very well that her testimony will be against me and in support of Randy. But I will call her nonetheless as a hostile witness. That is what our law says. But the court did not address his mind. They didn't even comment on Section 72 of our law on adverse witness, but rather adopted that dictionary. Then Dr. Ayine continues to say, I am sure for ordinary Ghanaians, listen to the way he framed this statement, for ordinary Ghanaians or the electorate generally, the fact that the Supreme Court judges, all 9 of them, on almost every application was unanimous in rejecting and dismissing the case of the petitioner was very telling in terms of the open-mindedness or otherwise of the justices as far as the petition was concerned, and for me as a lawyer. So he was raising questions. It raises questions about their open-mindedness or otherwise. These are not categorical statements of facts by Dr. Ayine that you lack independence, for which reason somebody can say that once you have made a categorical statement of fact, then you have impugned their integrity. Isn't this about as lawyers? We are allowed to raise issues of bias against judges that we are even appearing before. Not too long ago, you heard what Dr. Puni and his lawyers did in the High Court in the case presided over by Justice Onyuga. You can say that, my lord, because of what you have said in court or what you have done, raising A, B, C, D, I think there is a real likelihood of bias against you. Or I think that you are unfair, and that if you proceed with this case, I will not get a fair hearing. Even when you appeal a decision of a court, you are allowed in court to raise issues of bias. So assuming without admitting that, and in fact, in the media briefings, press briefings that we're doing after the court hearings, we're raising issues of what in our view constituted lack of fair hearing. That is not actionable. That is not something that impugns the integrity of the court. That is not scandalous. If I say that the way and manner the court has dealt with this application of the petitioner dampens my hopes about whether or not the petitioner is getting a fair hearing or is getting justice. These are comments that lawyers are allowed to make. Okay, and what Dr. Ayine said, he was talking about hopes, what the ordinary Ghanaian may think about the open-mindedness or otherwise. He qualified all those things, so I don't see that. Finally, this issue about the NDC's intrusion, according to Dr. and Mr. I keep calling you Dr. Bako. Maybe I should just give you the doctor. According to Mr. Bako.
The man ran away from an honorary doctorate.
You see, yes, Dr. Ayine was invited as a legal policy expert, but he was invited to represent the side of the petitioner.
Really?
That is why on the panel he was the only one representing the side of the petitioner. Okay. The side of Nana Addo Dankwa Akufo-Addo and the MPP was represented by Lawyer Opon. I'm sure that, I'm also told that Lawyer Kutu Ampao joined the conversation along the way. He was the only rep on the show who was coming from our side. So you cannot tell me that because the invitation said you are being invited as a legal policy expert, he was there in his personal capacity. Dr. Ayine is one of the most reliable, most committed, lawyers who are members of the NDC and who have been supporting the party. So if he's involved in this matter, the first matter we didn't wade in. In all the cases I cited, NDC-affiliated lawyers being cited for disciplinary action by the Chief Justice, we've never commented on these matters. Okay? In some of the cases, we have even encouraged them to apologize. But when the things are beginning to appear as if this is a trend, certain lawyers belonging to a certain fraternity are being targeted, and they are always the ones being referred to the disciplinary committee of the General Legal Council by one particular person, the Chief Justice for Disciplinary Committee, then it gives us as a political party genuine cause for concern. So wading into this matter was appropriate. It was not an intrusion, unwarranted intrusion, as Mr. Bako thinks. Then they claim that this issue about harassment of those who appeared there. Let me put on record, none of the lawyers who appeared there have told us that they were harassed. But whether or not an action constitutes harassment or not, it lies within the subjective opinions of people. So I don't get it.
So
you don't see it as harassment.
So it could be a perception.
Yes, and we are allowed to talk about what we see, right?
Formed by a certain trend.
If you see, that is why you can have powers as a police officer to do something, but the way you use the powers, the how you use the power, that power can give a bystander the perception that, no, I think you are abusing this power. It's becoming one too many. So it is within that context is important. It is within that context. We're not saying that the lawyers came and told us that. They said, Mr. Wako, when you have a case in which the complainant is the Chief Justice, head of the judiciary of Ghana, and chairman of the General Legal Council, knowing his stature and all that, it is not as simple as you may think. You understand? So let's not brand lawyers who appear before these committees of our pair training. Lawyers are trained to even say sorry to a judge, even when they are not wrong. Because you are taught as a lawyer that the law rests in the bosom of the judge. So you can go to a court. You see, Mr. Malcolm, the practice of the law is not the same as journalism. In journalism, when you think you are right,
journalism also has tactics. You were talking about tactics, so that's why I said strategy.
That's why I told him that because sometimes you may be on your feet in court making a case. You are right, but the judge says you are wrong. Because you want to.
A learned journalist is very strategic.
You have to concede, take a cue from the bench, and move on. Because whether you like it or not, the law is in his bosom. Yeah. So a bystander or another Ghanaian may see that as cowardice. But in the practice of lawyers, it is not cowardice at all. That's all. So please, I will once again appeal, and I think Mr. Bako and I agree on this one, to the Chief Justice that let's allow this matter to die a natural death.
Right.
Dr. Ayine has been a very good friend to the court and has been very, 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 if you like, responsible.
In fact, he's a former member of the General Legal Council.
Yes, and as a member of the General Legal Council, former Deputy Attorney General, at different times he worked with some of the justices of the Supreme Court and even the current Chief Justice. They know him. They know that this is not a man who is irresponsible and all that. This matter can be allowed to die a natural death, and we all go away. But if people decide that because we have power, we will show you where, I'm told that some people are even saying that because the NDC has withered in and all that, and because of that they will show him where the power lies and all that is necessary. It's unnecessary. It's needless. Okay. People will not be in those positions they are today forever. So when they are treating people this way, they should be mindful.
Is this a new line?
Oh, it's not a new line.
About holding a position forever. It appears that yesterday's by John Jinapor has become very popular and powerful.
Be in those positions for forever. So when they are taking some of these decisions, they should be mindful that the tables can turn. You understand? People should be free to voice it.
Randy.
Yes.
You know the difficulty I have is because I don't want it to appear as if I really am against what Dr. Ayine said at that forum because of the context. Because my position is very clear there. So I don't believe in debating.
So what is your position?
I'm coming.
Yes.
I'm coming. I don't believe in opposing things being said on his behalf as if it's a position I share. Do you understand? Because as I said, the forum...
You fear you could be misunderstood.
Yes. And there are a lot of people out there who do selective hearing.
Oh, but you've been very supportive on this one.
My point is that the context, the forum, was such that it's permissible for him to have said the things he said and for the CJ to ignore and move on. That is the principal position I hold. And I've held this position from day one. And indeed, that's why I was happy when I read his thing. And I realized that he's prepared to face the disciplinary committee and make his case. And face the consequences. Assuming the sanctions happen to be unfair to him, he knows what to do. We've discussed that. That's where I stand. So I'm very careful how I go about it. Otherwise, people might think, look, this man, what's his position and all that. It's clear. My position is very clear. But you see, we're not about to re-litigate the election petition.
Yeah.
It's gone out of the window. Thankfully, it was telecast live. We all saw what happened. So Sami and his party have their own views and reservations and things. For me, they could have subjected it to review, of course, almost like a Mission Impossible if you look at the numbers alone, and whether the judges will be minded to change their positions or not. We all know these things happen in the judicial history. So they didn't go for the review. But that was the only option left for them if they thought things didn't go right in accordance with law.
Right.
They had to go for a review. They didn't go for a review. So case closed, as far as I'm concerned. It's now left with intellectual critiques and analysis and where Ayeni's team comes in, dependent on the forum. Yeah, I think you get my point.
Yes.
Yeah. Now, the point about lawyers are trained to say sorry and things to judges and all, that's in the courtroom when certain things are unfolding. And there are times a lawyer slip and can say, oh, my lord, sorry, and then you move on, or the judge can say, yeah, that's in a courtroom. That's not the same thing like appearing before the disciplinary committee.
They have the powers of a high
No, I'm not talking of the powers. I'm not talking of the powers. In court, when you are making your case, really, you are not on trial. You are not being subjected to any disciplinary action. That's the point I'm making. That's the point I'm making. I'm not talking of even the laws and the rules and all that, even though there are differences. Even if you read this, then there are differences. But the substantive point I'm making is that when you are in court and making your case, advocacy and all that, and something happens and you apologize, it is not the same as when you've appeared before the disciplinary committee on a charge. Indeed, last time when I referred to Rule 52, subsequently in my checks, I was told that, look, it was premature for even one to talk of the Rule 52 because he hadn't been charged with any offense. Yeah. Okay, so it's like the Chief Justice say, investigate that matter. It's the investigation that may lead to a prima facie basis that now, okay, so this is when it comes before the committee, this is the charge. So really, it's as if there's some premature, in the process.
In the morning.
The case are watching me, So that's the way I see it. Bottom line, I really think that this intrusion was not the right one. It makes things difficult. It makes those who are seeking mitigation or amnesty or withdrawal difficult. You see, undue politicization of this otherwise professional, strictly legal issue. I would have wished they hadn't intervened.
Right. Right. So, Kwewu, what do your documents, your intel, your intercepted intel, and your sources, and the ears and eyes that you have in strategic places say about the $170 million judgment debt?
See, judgment debt is not every judgment debt that is, better choose my words carefully, it's reckless or, criminal. It's not every judgment debt that is tainted with corruption.
Okay, so what you mean to say is that it is not every judgment debt which is a creation of fraud.
Something, precisely. I think it's a better way of communicating. Because if you go for the history of judgment debts, you see there were some that were unavoidable, sometimes based on people's conduct here and there, even the text of the agreement that we signed and all that. There are also some that clearly were vitiated by fraud. It's difficult. The Woyome one was clear in the sense that Woyome had no contract with the government of Ghana. So there was no basis for him even to have been entertained, or his petition or whatever to have been entertained. And so that's in a context. There are many other judgment debts that if you go deep into it, yes, some poor judgment, error of judgment here and there, but not tailored to make private gain.
Not manufactured.
Not manufactured, and not because somebody wants to make some private gain out of it. So one has to be very careful when we are discussing it. In fact, you go to take a look. I was looking for my report. I couldn't find it because it's mixed up. Just as Up House committee, the commission.
Yes.
There's a lot in there, that shows the difference I'm trying to draw. Fast track to this one. There are 3 areas, Randy. First of all, the contract itself, the arrangement, the agreement. Then 2, the breach, the termination. Then of course 3,
the arbitration.
At this stage, where there's a judgment debt of 170 million, is it pounds or dollars? I think the focus legitimately could be on the arbitration, what happened, how it happened, and things. Even though you cannot divide, draw a Chinese wall between the first 2, because
as for the termination and arbitration, they are directly linked.
They are linked. Yes, that's what I mean. You can't put a wall between them. The termination, of course, was based on the agreement. Whether the agreement was fulfilled or not fulfilled, in the opinion of the Attorney General.
So the termination was based on the appreciation and interpretation of the agreement by the legal, the Aegis department.
Yes. Who thought there had been difficulties, challenges, non-fulfillment of certain conditions precedent by the contractor or the business person, So that led to the termination. Look, the arbitration, I hear people say, oh, we didn't defend. We did.
No, up to the award.
And you know what? Those awards, they are not appealable, strictly speaking.
Why are they not
awards? Yeah, that is what it is. Check with the lawyers.
But the law allows you to.
They are final. That kind of arbitration award was final. What the Ghana government sought to do, really, to play around to see if there could be a window of opportunity, was dead on arrival. Take it from me.
So I'm sure that you've seen the rejection of the extension of time by us. What was supposed to file on the 8th?
Look, that thing.
Yes.
It wasn't going to work from day one.
Not whether it's going to work or not work, but when you read it, the comment of the head of the panel suggests that by law you had a period to do something and you didn't do it. Whether it will succeed or not is another matter. The fact that you even attempted to do it means that you believe you could do something.
Well,
so you either don't go at it at all and say that
yes, I hear you, all right, but I also, of course, did some independent checks here and there, and with some authorities, and I'm told that move was dead on arrival. We lost. The judgment was given 22nd January 2021.
Yes.
Wasn't it?
Yes.
Yes. So we put in a defense all along, and then we lost 22nd January 2021. From there, all the attempts we made actually were needless and fruitless. It wasn't going to work. That's the advice.
So why did we lose?
Why did we lose?
Yes. You know why I asked that?
Yeah.
The arbitration was a consequence of the termination.
Yeah.
The termination was on the basis of the advice of the Attorney General's department, per the understanding of the terms of the contract. So why did we lose?
Well, right, if you have a bad case, you lose. You know, because I think the termination, maybe the problem was with the termination.
Yes.
That's where I think the problem was.
That's the basis of my question. You still don't get it?
Yes, I get it. But
yes.
That is where the problem was. The termination. and post-termination
handling of the matter.
You know, things before it even went to arbitration. Perhaps there was a window of opportunity to renegotiate.
Because it appears that the company did not accept the 80 million.
Yes, they didn't.
Yes.
They didn't.
So that's where the window you're talking about.
Yes, they didn't. And so when we thought, look, we're right. And truly there were parts of the agreement that also were a bit problematic. Do you understand? And the people themselves had also not fulfilled certain conditions precedent. But still,
whether those conditions that they have not fulfilled were weighty enough to merit a termination.
Yes, but that is why I'm making the point that the termination was the key fault line. I'm being honest with you,
right?
Based on the latest analysis that I have made,
right?
And it's difficult. I don't. There's no need to personalize,
right? You can just deal with the office. That's fine.
Yes, yes. So that's where the problem was. In spite of that, when they went to the arbitration, they put in a defense. Perhaps that is the stage that you think you are trying something to see whether you could win or even mitigate. At the end of the day, it was obvious that it wasn't going to happen.
Because it's simple.
Let me be honest.
I have an agreement with you, and I believe that per the terms of the agreement, you have occasioned breaches which can lead to a termination. That's my belief. And I have the legal capacity to make that determination and advice. And I say that is it. If you are dissatisfied and you go on arbitration, I pretty obvious must use my basis for the termination to justify my action and to prevent the award of that cost against me.
Yeah. I agree.
So we have to pay.
You pay. It's ended.
Must we hold people responsible? And you see,
that's the next leg.
Yes, because I go back to what you started with. You know, that yes, you could have a situation where you think that people crafted and created something, you know, in order to benefit from it. Now, when people are also put in positions of trust and authority, shouldn't they also be held responsible? Because at the end of the day, both actions, to the extent that they lead to a loss to the state must be interested in holding people culpable.
The principle is clear, and we all ought to support that kind of principle. I asked myself, what have we been doing since we were confronted with the challenge of judgment debts, especially the negatives? Take a look at the Justice Apau's report. Whole lot of recommendations pointing to the sources of why those particular ones happened. Those that were unavoidable, he states them there clearly. What have we been doing? Virtually nothing. And perhaps it means we are not creating a culture of deterrence. And because we'll be living here with judgment debts for a while to come, there's a need for something to be done. I have no opposition to the need to investigate and, if possible, to sanction. I have no problem with that.
Have you heard the Attorney General, and today, I think on the front page of your paper, say an MP for Doma East or something, saying that those who signed the contract, those who entered into the contract, ought to be prosecuted. I've read one where the Attorney General says he's going to ask the CID to haul those who were involved in the agreement for investigation.
If you are going to take action, it should be comprehensive. Yes, take a look at those who signed the agreement. If the agreement was really well situated, it's a legitimate inquiry. Those who terminated it, they have to be part of the investigations. Why did you terminate it? When you terminated it, was there a window of opportunity to have done some renegotiation? That's a legitimate question. And then the arbitration. But the point I'm making about arbitration is that indeed there was a defense. Okay, unless you are going to question the quality of the defense. But there was a defense.
Yes.
Till the last day, when January 26th, when the final award was given, there was a defense.
So that's been my line all this while. That look, your basis for the termination is obviously your defense.
Exactly.
So to the extent that your defense collapsed, then the basis for your termination.
Yeah, but that is why I say that is the key, the termination. Because you see, the arbitration, if they hadn't put in the defense from beginning to the end, then I would have a difficulty there. They did. The records show that they did. The contract itself, there were defects in it, but it still wasn't the key problem. In the sense that once you terminate it, that's where the whole unfolding thing began. I don't know if you get.
Yeah, because you were convinced that you had legal legs to stand on.
Yes. And you know the termination, of course, the Attorney General's advice to terminate or decision to terminate was based on a committee's report. They evaluated the committee.
But they were not bound by it.
Oh, you see, let me tell you, Randy, this contract was part of about 11 or 12 PPAs that were subject to review.
Right.
And in fact, what people don't know is that the review began at the Mahama administration.
Yes.
Somewhere September.
The process to review.
Yes.
Yes.
It was based on a World Bank recommendation. I'm sure I've been sending you messages on this before. That's when it started. November 2016. The World Bank team visited Ghana. They had a meeting with President Mahama, Setepe, and others. I think Jabesh, Misata, and somebody else represented Ghana in the meeting. And they came to a conclusion that some of those PPAs constituted a potential overcapacity, and that if the Mahama administration proceeded with them, it will be running into about $680 million or $580 million annually, and that it will create challenges for the power sector. The Mahama administration agreed with this observation made by the World Bank team, and so put in place a committee to review other matters, including these ones. I think the only thing that might have changed post 2016 was that the membership, the chief director or so, was removed, and the new one came on board. All the list of members are here. It was headed by the Energy Commission, Executive Secretary, and they looked straight into the agreements. When somebody comes in, I'll check into and came to conclusions on each. Those that had to be continued because they had reached a certain extent. Those that had to be deferred into the future, and those that had to be terminated, about 3 or 4, one of which was this one under contention now. No. So there was technical, financial, and economic reasons for recommending termination of some of those things.
I don't have a problem with that. But I'm saying that when for example, it will go to the Attorney General because you also need to examine the document and look at whether there is a basis for termination. And if there is, what are the repercussions of same? You get what I'm saying?
I'm with you on that. I'm not debating that at all.
Because there will be evidence of recommendations that this government, on assuming office, has not gone with.
Yes. Yes.
So it means that they are not bound. They would evaluate them, and if they agree with those ones, they will proceed. If they disagree, they will take a different turn.
For instance, on this agreement, is it the GPGC?
Correct.
The recommendations or the observations, just one part. It says emergency power agreement for 107 megawatts combined cycle power plant to run on new NGs, new gas, isn't it?
Yes.
Yes.
Natural gas.
Natural gas, thank you. Executed on June 3rd, 2015 by Ministry of Power. It is made up of 2 power blocks, with each block made up of used gas turbine and steam turbine, with years of manufacture as 2003 and 2004 for block 1 units, and 2011 for Block 2 units. The committee knows that GPGC does not have a provisional license from the Energy Commission. This is one of the reasons the Attorney General used. I have the letter here, later I can check. So the termination, based on a technical evaluation by a committee of experts, the Attorney General can argue that yes, so I did it based on this.
I agree with you, but the absence of a provisional license cannot be sufficient grounds to breach.
There are many more.
No, I'm just saying that, for example, the committee could reach some conclusions, and the Attorney General's position could be that, look, yes, you've said this, but it cannot be sufficient grounds to terminate.
That alone cannot be.
Yes.
But there were other reasons. I'll check and read those reasons. But whatever it is, once you terminate it, and the guys disagree with your termination, there's, before even you go for arbitration, there's some negotiations. There was a up and down type of thing before it went to the arbitration. The arbitration, we lost.
Yes.
And we've been asked to pay 170 million. You will pay.
What was going to be the total value of the contract over the 4 years?
96.9.
No, let him come. I'll check. I'll check him.
Okay. So I thought it was 20 something a year.
It is 24.9 a year. So in 4 years, 96 million.
If it had been executed.
If it had been maintained.
You
it was
go
executed.
Let me check.
All right. Okay, so let me bring it.
Okay, Doc. Thank you very much.
Okay, it says.
Yes.
Let me read.
Okay.
It says. Okay, this is installed capacity is 107.
Yes.
Expected commercial operation date was 2018.
Right.
Then proposed modification to the PPA, this should be terminated.
Okay.
Then remarks. It says this is an emergency plant with a 5-year PPA. Used plant, not new, and high tariff. Major equipment has arrived at the Tama port awaiting tax exemption to clear. Based on the 2018-2030 demand-supply capacity balance and the tariff rank of this project, the full capacity of this project will be excess, that is idle, resulting in estimated total cost of $115.48 million within the duration of the PPA. The likelihood of the plant being idle.
How did it move from 4 years to 5 years? I thought it was 4.
Well, but this is
right.
This
you're reading from the
appendix.
document.
What's the name of the title of the appendix?
Are you sure you have the same document?
This is summary
3B. Or
no, table 9.1.
Okay.
Yeah, it says the likelihood of the plant being idle is further heightened by the fact that it is a pure natural gas fire turbine to be located in Tama where there is inadequate gas to feed it. There is therefore a high probability of the plant remaining idle even if allowed to proceed. The actual development cost of the project to date should be verified and used as a guide in negotiations for termination.
So this is the recommendation.
These are the recommendations.
Okay. This is not a recommendation, but I will explain. This is contained in the body of the report, but that is not the recommendation. But I will do it. You see, one day, Mr. Baku says that not every judgment debt is tainted with fraud or corruption. That is true. And I will not say that this judgment debt is tainted with fraud. But I can tell you that this judgment debt is tainted with criminal negligence and criminal recklessness. And that is why I am sad, sitting here as again, and that is why I'm heartbroken. Because we've been slapped with this $170 million judgment debt, which is accruing interest on a daily basis, compounded on a monthly basis. Because of the criminal negligence and recklessness of the Kufuor government. They are the ones who have caused this huge financial loss to the state, and therefore must be held responsible. So yes, they may not be fraud, but there is criminal negligence and there is criminal recklessness. It is so clear that that is the reason why we are where we are. You see, there has been some attempts by the Attorney General and Mr. Bako, some way, somehow, has rehashed some of those statements by the Attorney General. That the agreement which was signed, the emergency power agreement which was signed between ECG and GPGC was defective. The Attorney General says that it was structured in such a way that it imposed unnecessary financial liabilities on government. And he has even said that the agreement was unnecessary. Randy, that is not true. This agreement was very necessary. The execution of same under the Mahama administration was proper and regular. We were in the midst of a severe doomsday crisis, owing largely to a generational capacity shortfall that needed to be addressed. We had a lot of PPAs and EPAs at the time which had not materialized. And so the government had to deal with that power shortfall. And that is what led to the execution of some of these EPAs and PPAs. We needed the power, but the Mahama administration was not just interested in achieving an equilibrium between demand and supply, producing power to meet our immediate needs or power demand as a country. But we were forward-looking and even looking at the possibility of increasing our exportation of power to neighboring countries and other countries. Because since the 70s, we've been exporting power to Benin and Togo, Burkina Faso, and we had plans of even increasing that. So that is what informed the execution of this GPGC EPA. The agreement was not only ratified by cabinet, but agreement was ratified by Parliament on the 23rd of July 2015.
It was approved by Parliament.
It was approved by Parliament. It was signed on 3rd of June, and it was approved. And the memorandum to Parliament presented by the minister, then Honorable Dr. Kwamina Donko, is what is before me, with the agreement attached. Parliament as a house, with the MPP participating both at the committee level and also at the plenary, approved the agreement. So this post facto issues of the agreement was defective, the agreement was this, that is neither here nor there. Godfrey Dame doesn't know better about power agreements than Matthew Poku Prempe and members of the MPP on the Energy Subcommittee of Parliament, who all vetted this agreement and approved it both at the committee level and at the plenary. So let's stop that. Randy, I can tell you, I've gone through this document, that this GPGC agreement was one of the best, if not the best, that we executed. Yes.
I've heard the then Power Minister Kwabena Donko say that the tariff for this agreement
it was the cheapest.
Yes,
this is it. It was 4 cents. Capital recovery of 3.7 cents and fixed O&M charge of 0.3. Total capacity charge of 4. Car power was 5.6 cents per kilowatt hour. SEM power was 5.04 cents, US cents per kilowatt hour. This was 4 cents. Again, if you check all the other agreements, the duration was 5 years and above. Car power was 10 years. This one was 4 years. Very short.
What did the agreement to Parliament say about the duration?
It was 4 years.
4 years.
I can read that to you.
Okay.
Then apart from the duration...
Who was reading, I thought I heard something like reviewed PPA.
Oh, it's here. I will show you.
Which means that subsequent...
Because that report is of dubious validity, and I'll come to that.
Okay, let's go on.
That report is of dubious validity. Mr. Bab, look, apart from that, under this agreement, this was the only EPA, or one of the few, that government of Ghana was not supposed to provide financial security in the form of guarantee. Okay. So it was very easy for us. And it was very cheap. We executed it. It went for cabinet. It went to cabinet for approval. It went to Parliament for approval. Nothing improper was done. You came into office in 2017. And then you decided to terminate the agreement. And the letter of termination, which is dated 13th February 2018, a copy of which I have here, didn't make reference to any issue of excess capacity charge as a reason for termination.
So this is the letter to the company.
To the company.
So
by Boakye Agyarko.
So this letter,
which he says he wrote on the orders of cabinet chaired by President Akufo-Addo. So you see why you can't blame just Boakye Agyarko.
Because you see, at the end of the day, all the commentary about what is wrong with the agreement, as far as the termination and arbitration is concerned, is inconsequential.
Yes.
What is important is this letter.
The grounds for the termination.
Because this letter gives the grounds for termination.
Exactly.
And it is on the basis of this letter that the company will go for arbitration.
Exactly. And Randy, in this termination, they gave about 3 reasons for this letter. They gave about 3 reasons for the termination. They said that the company had failed to fulfill certain conditions subsequent.
Right.
The agreement said within 30 days after the agreement becomes effective, the company is supposed to fulfill certain conditions subsequently. Government of Ghana said, look here, you've not fulfilled. So the EPA is null and void. Then some of those conditions were that you were supposed to get a license from the Energy Commission in accordance with Section 11 of the Energy Commission Act to allow you to engage in the sale of electricity in Ghana. Our check shows that you don't have that license as at the termination date. You were supposed to get siting and construction permits for your plant. We've checked, you don't have site. Even though you've built something, you don't have permits. You were supposed to achieve financial closure by 3rd August 2018. We've checked, you don't have financial closure. You've not achieved that. These were the reasons.
So if these were the 3 reasons given in the letter,
yes. The termination letter. This is what it says. In accordance.
Do you have the AG's advice?
Yes, I will make reference to that. He talks about the fact that the plant was used.
Just a minute. Just a minute. Let me say a clarification from Koku. The AG's advice, did it precede the termination letter, or was advice after the termination?
No, what's the date?
What's the date of the termination letter?
13th February 2018.
No, the AG letter came late. The AG's letter is August 2018.
So that's, I'm going there.
Just a minute. So it suggests that
28th August 2017.
Yes.
Okay.
So it was before.
So most definitely, the AG's advice was advice to government.
Yes.
Yes, of course.
And that would form the basis for the termination.
Yes.
Yes.
Okay. But the termination letter itself did not even make reference to some of the.
So this is the termination given to the company. The AG's advice will not be given to the company. The AG's advice will be relied on by. Yes. So as far as the company is concerned, what is indicated in the letter as the basis for termination is really what the issue is.
That's what they are challenging. And this is what it says.
To the arbitration, the defense will then have to
include
reflect.
more things. And I will come to all that. It says the letter says, in accordance with the terms and conditions of the agreement, the agreement should not have become effective on 3rd August 2015, except the parties mutually extend the period for the fulfillment. Should have become effective on 3rd August 2015, except the parties mutually extend the period for the fulfillment of the conditions precedent to the effectiveness of the agreement. Following a review of the agreement and the project, we know that the parties have not mutually extended the period for the fulfillment of the conditions precedent. We also know that to date, GPGC has not reached financial close nor achieved full commercial operation date, primarily because of some of the preconditions or conditions subsequent for the achievement. Then they say the ministry has been informed by the Energy Commission that GPGC has still not obtained a license from the Commission to engage in the business or commercial activity for the sale of electricity. GPGC therefore has no capacity to execute the EPA. Accordingly, the EPA is null and void for want of capacity. So license. Similarly, although it is a requirement to obtain siting and construction permits from the Commission prior to construction and installation of a plant for the production and supply of energy, GPC has commenced construction on site without the requisite siting and construction permits. Accordingly, GPGC's construction activities are illegal. These were the reasons you gave for the termination.
My question to you, you're a lawyer. My question to you, if the basis for terminating an agreement is the non-fulfillment of conditions precedent in that agreement, how can anybody turn around to fault the agreement?
So, yes, it doesn't make sense. But they were even wrong. The reason is that when the matter came up at arbitration in London, the arbitration panel, all the 3, At arbitration, government of Ghana nominated or selected one arbitrator.
I think we had Professor Fiajo or something.
Yes, Professor Fiajo. Yeah. Then the company selected one, and the two selected another. All the three dismissed all these reasons that we didn't have a case. And you know why they dismissed? They said, number one, in terms of the license from the Energy Commission, the records show that the company had applied for the license, but the board had not been constituted as at the time of the termination. So they had applied for the license, but there was no board. Number two, in terms of permit, and I'll read that to you. Check the arbitral award, paragraph 479. They say that we disagree with you on the issue of permit because the records show that the company had applied to the Pong Katamanso District Assembly for siting and construction permit. So you lied that they didn't have a construction and siting permit. They have it from Pong Katamanso District Assembly, paragraph 479 of the arbitral award. They said that you spoke about
to suggest that the government of Ghana,
we contrived reasons.
Yes, but is it to suggest that the government of Ghana didn't have the capacity to find out whether a permit has been issued by
they were determined to terminate the agreement at all costs, even though they knew they had no basis to do so. That is the point I'm driving at. Right. Because this is, and time will not allow me to read all these things.
Otherwise, my point is that it should be easy for even me sitting here to find out from an assembly whether they have issued a permit or not. And you see, Doc,
the termination agreement this letter alluded to says that you can terminate on grounds of non-fulfillment of conditions precedent or conditions subsequent by a party. If that non-fulfillment is the fault of the defaulting party.
Right.
That is it. Right. That is section 4G of the agreement. But the court found out that even with the other conditions subsequent that you claim the company has not fulfilled, for example, they were supposed to do certain tests. Government of Ghana was required to provide them with the samples for them to do the testing. You have not provided them with the samples, and you claim they are in breach. So the arbitration panel said, apart from some of your claims which are palpably false, like the lack of construction permits, license from the Energy Commission and all that, the other conditions subsequent have not been fulfilled as a result of your own fault as a government. And so it is even the company which is entitled to terminate the agreement. That is what everybody who has arbitral award should go to paragraph 479. Then you say, Randy, so it means that we have no basis to terminate. Okay. Now, they have made a claim that, oh, this termination was on the basis of the PPA committee recommendation. A committee that started its work in September 2016, like Mr. Marco said. Now, September. The reason why 16. You see, and that committee, when they started their work, it was chaired by the then acting secretary, executive secretary. No, Michael Upam.
Okay.
And they were the ones who produced the original draft report. Ahenkra was then working with the Ministry of Energy. When this new government came in, he went back to Energy Commission and he took over from Michael Upam. The report we have now, which is what Mr. Bako is referring to, a copy of which I had here, in which it was recommended, and this was the recommendation, you read from the body, the recommendation which is found on page 37 is that government may, not should, may, consider terminating the PPA of GPGC, executed between the government and GPGC, with an installed capacity of 107 megawatts, at an estimated cost of $18 million. 18. Or else pay excess capacity charge of 24.9 million per annum over the contract period of 4 years.
Okay, so the report was at 24 point something.
0.9. That brings it to 99.6 million in 4 years. Okay. This is the recommendation.
So that would have been the contract value.
Yes. Okay. If we had maintained the agreement. Right. Now this report, which we are all making reference to, is not signed. Why is this report not signed? Because you know why, Randy? When Ahenkra appeared before the arbitration panel and he was cross-examined, he said he cannot recollect that the committee recommended for this EPA to be cancelled.
That can be true.
Oh, let me read it. Please. Paragraph 490. One of the PPAs recommended for termination was this arbitration panel, was the GPCGC project. Dr. Henke's committee suggested that termination could be achieved for some $18 million, as opposed to payments of $24.9 million a year for 4 years in excess capacity charges. The basis of that recommendation is not known. The copy of the PPA committee report submitted into the record by GOG is heavily redacted, meaning that it's been parts have been obscured, edited. Yeah. And they said they were doing that to protect third parties. Okay. That report which they claim is so material, the report which formed the basis of the termination, you went and edited portions. Now, it's heavily redacted, notwithstanding the tribunal's order that the unredacted text be disclosed. Under cross-examination, Dr. Hinkra equivocated as to whether he had any recollection of the particular recommendation made in respect of the GPGC EPA at all.
Please read that part again.
Let me read it. Okay. Under cross-examination, Dr. Hinkra equivocated as to whether he had any recollection of the particular recommendation made in respect of the GPGC EPA at all, just as he has sought to distance himself from the AG's advice of August 2017.
Wow.
This is Dr. Hinkra.
Wow.
This is the arbitration panel's decision. The man went there and said, even what the AG said in her advice, I disagree. I distance myself from it. And I don't recollect. You know why? Till date, this government has not been able to produce a signed copy of this report. Because the information some of us have is that the original draft does not include any recommendation for the GPGC EPA to be terminated. If it included it, why did Dr. Hinkra, who took over from Michael Opam as the chairman of this committee, said he cannot recollect that they made any such recommendation? Why? So you terminated an agreement. There was nothing like excess capacity charges like you are seeking to rationalize, your decision to terminate now. You gave reasons. Because of time, I would have read paragraph 479. The arbitration panel says all your reasons are either lies,
that's exactly,
or without any basis, and you were even in breach.
That's exactly the point I made from the beginning, that your basis for termination is your defense at the arbitration.
Yes.
So if your defense at arbitration collapsed, and even your choice of a member of a panel
ruled against you,
you don't have a big problem.
And you see, Randy, let me talk about, before I deal with this issue of excess capacity. So for me, we need to investigate the circumstances surrounding this so-called recommendation. Because Hinkra, who chaired the committee, says, I don't recollect. He went there and even distanced himself from the advice of the Attorney General. To date, we don't have a signed copy. And we are picking information that the members of the committee refused to sign because of this insertion. The Herald newspaper has published something that is also worth investigating. That this whole termination is based on a feud between family and friends of President Akufo-Addo. One brother of President Akufo-Addo wanting to show the country rep of the company, who is a family relative, called Damien, where the power lies. So we may be dealing with a rift between family and friends of President Akufo-Addo, and not any real breaches or non-fulfillment of any agreement. Randy, assuming without admitting, for purposes of argument, that we even had a basis for termination, look at how we conducted this case. You went for arbitration, the seat of arbitration being London, governed by English law, with lawyers from the AG's department and a Ghanaian law firm, no English firm. Who does that? You went with Amufa and partners. And you see, I've seen...
But I thought we hired two...
No, at arbitration, lawyers from the AG's department, led by the AG and her deputy, the one who is playing Pontius Pilate, Godfred Yebu Adame, and creating an impression that, I didn't know anything about this thing. It was until my swearing in as AG. Randy, the arbitral award says we were represented by these lawyers. Let me read that to you, so that everybody will know that Godfred Adame was part. Omnia Strategy, owned by Sherry Blair, the wife of Tony Blair, came in after the arbitral award had been given. So they came in to help us to set it aside.
But prior to that, there were some two QCs. There were two QCs.
But this is what there's a council for respondents. The respondent is government of the Republic of Ghana. Miss Gloria Ifua Akufo. Mr. Godfred Yebu Adame, the one playing Pontius Pilate. Mrs. Helena Penny Awuziwo. Mrs. Amapel Akwewumi Serebo, Mrs. Grace Opondorfi, all from the office of the Attorney General, and Amufa and partners, a Ghanaian law firm. Now you went there, failed miserably. Then when you then decided to challenge the arbitral award, you now decided to go for an English law firm, Omnia Strategy, which is owned by Sherry Blair, the wife of Tony Blair, with high international repute. When they took up the matter, went to court, because we had a 28 window to challenge the arbitral award. When they went to court on the 25th day to ask for extension, or 56 days, the court gave us up to 8th March. Then after studying the documents, that law firm of international repute realized that we didn't have any good case. And so they backed out. Omnia Strategy backed out. And then they said we should. Then we went for another law firm called Volterra Theatre. All of these law firms we have paid with taxpayers' money. And it is this law firm which filed their so-called process to set aside the arbitral award on the 1st of April, 23 days after the extended deadline for challenging the arbitral award had lapsed. So look at the sloppiness, the recklessness, the incompetence that the Akufo-Addo government, through the Attorney General Department, exhibited in the conduct of this case. Is Godfrey Dame telling us that as a lawyer who was on record in this case, he didn't know that the arbitration panel has set 22nd January for its arbitral award? And didn't they know that by that time he may not be in office, the Solicitor General may be acting, and the other lawyers who were all on record representing the state could take steps to set aside the arbitral award? What plans did they put in place in their handing over notes? What instructions, what directives did they give? And Randy, so you see, we are here, like I said, because of the criminal negligence and recklessness of officials of the Akufo-Addo government. It starts with Ejako, the Minister for Energy, the Attorney General, and her deputy. Godfrey Dame cannot be extricated or exculpated from blame in this case. And the cabinet headed by President Akufo-Addo, who took this reckless decision to terminate an agreement based on claims which they could not substantiate before an arbitration panel, such that our own selected arbitrator had to rule against it. And then finally, in just 2 minutes, this whole talk about, the Mahama government executed too many EPAs and we are paying excess capacity charges and all around it. That matter has been settled. It's been proven to be false, and we just have to let the people of Ghana know that that claim is false, so that our friends in the NPP can stop disturbing our ears.
Are you referring to the Sweeney?
The Sweeney question. He asked a question for the Minister for Finance to come and inform Parliament about the total amount of money we have paid to companies in excess capacity charges. This is the answer of the Minister for Finance. He says that from 2017 to 2020, in total, we've paid $937.5 million in excess capacity charges to 3 companies. Now, according to the Energy Commission, and this amount is for 4 years. So when you divide it by 4 years, you get the annual average, which is $234 million. 234. That's the figure we are talking about. According to the Energy Commission, the reserve power margin of ECG constitutes $200 million of that amount. So that is not excess power. It's like a football team going to play a tournament.
But what are the 3 companies?
AXA, Car Power, and Sen Power.
So those are the only 3 companies who paid excess?
Yes.
Those are the only 3?
Yes.
Okay.
And you see...
And these are companies that are generating power for us?
And Car Power, we have extended the agreement from 10 years to 20 years. Okay. Sen Power, we have extended the agreement from 5 years to 10 years. Yet we claim we are paying for excess capacity charges. Right. I'm saying that even that 234 million, 200 million of that is reserve margin, which is a necessity, a standard practice, because the system is such that on the pitch you have 11 players, but you need 5 players on the bench, which is a necessity. That one is not excess. And the so-called $34 million left could have been totally wiped away if only VACO was brought on stream. Or even if B5 Steel Company Limited was given the power they are asking for. Or if the 330 kV transmission line from Ghana to Burkina Faso, which would have ensured an increase in exportation of power from 100 megawatts to 200 megawatts to Burkina Faso was completed by this government.
Right.
You've not done all these things, okay? You have even extended the duration of some of these agreements. As we speak now, there are companies in this country who are asking for power, they are not getting power. And you keep disturbing our ears with excess power, excess power. All that, the claim was that they were paying $1 billion per annum. All that has been proven to be false. So they should stop disturbing our ears. Godfred Dame, if Ghana was another jurisdiction, he would have resigned by now.
Okay.
People should be resigning.
Okay.
And lastly, I agree with Mr. Bako and yourself that people, because criminal negligence, if you look at the offense of willfully causing financial loss to the state, Randy, people have been in prison for losses to the state less than $170 million. You understand? So people should be prosecuted, people should be held as accountable.
Right.
Let's attempt to blame government officials who left office 5 years ago for your criminal negligence and recklessness in terminating an agreement you had no business of terminating. It's neither here nor there. They should stop disturbing our ears.
We'll be back shortly to continue.
In Ghana and in Africa, there is only one place to look to get that luxurious design and decor for your offices and homes. Visit Jamila Home. We give you the climax of luxury wherever you find yourself. Presidential and executive office furniture, living room sets, dining set, stunning mirrors, adorable wallpapers, lovely king and queen size beds, valuable antiques and antique goods, beautiful chandeliers and more. Into the bargain, we provide caring customer service, prompt delivery service, skilled and artistic full house design and decor services, and free decor ideas for your space. Our products and service is unparalleled, boasting of top-tier clients all over the globe. Jamila Home, home of first-class quality furniture, beautiful chandeliers, and antiques.
Masa, Tam, Maria, I'm kind of coffee. I am doing more budget bonnet. Have a beer, you can have a beer.
HD logo the bottom. Where you say HD local channels na mo bedo. And so pictures here clear. E 5 times better. As in other channels go be show hormone. So go dey mention mon tram rock why. Oh, what a pictures. What a picture. What do AD plus decoder or multi TV and now Electroland agent PR natural local channels now HD the here is better star 879 hash numbers from Kubu box and now the advert AD channels now.
Get an HD Plus decoder from now till the 9th of August for just $89.99 Ghana cedis and enjoy 3 months free subscription. Enjoy all the excitement and live sports action in the HD Plus Air Bustle Feely promo. Promo lasts from 7th June to 9th August 2021. Visit hd-plus.com.gh or call 024-243-9872 for more info.
Half a nose for good things.
Right, welcome back to the show. If you just joined us, this is Good Morning Ghana Live on Metro TV. Shows brought to you in kind partnership with Natural Mineral Water. And still with me on the show, I have Sami Jemfi and Abdul Malik Wekubako. Yes, Ojan.
Yeah, Randy. See, it is a fact that the Mahama administration conceded that they had signed PPAs and some had begun and all that, which had led to excess generation capacity. It's a fact. One of them was this company. See, this is a World Bank. See, World Bank letter. Aid memoir. Dated November 13, 2016. I'll read the relevant portion. Paragraph 4. Excess generation capacity. In addition to existing installed generation capacity, there are a number of new power generation projects that are either under construction, have been committed, or are in advanced stages of finalization. These are expected to result in further excess supply capacity beyond total demand plus reserve margin for the period from 2017 to 2021, reaching a maximum excess generation capacity estimated to be 1,700 megawatts in 2020. The capacity charge in respect of this excess capacity alone will total $680 million annually and would contribute to further deterioration of the financial condition of the energy sector, as well as increase the country's fiscal deficit. To avoid or mitigate the expected excess generation capacity and the associated cost, the government of Ghana agreed to take the following actions. A, development of all new power projects will be suspended through a formal cabinet decision that will reaffirm the earlier directive from the office of the president for a moratorium on new IPPs, independent power producers, I believe. B, legal and financial reviews of the signed PPAs and MOUs of committed and advanced projects will be conducted to decide on which projects will be delayed, deferred, or cancelled. Then this is the relevant part, because the other one is on VALCO. So there is no denial of the fact that at a certain stage in our power history, the government and the World Bank agreed that we were going too fast with too many projects at the same time.
We needed to do something.
And we needed to do something. It is that needed to do something that occasioned the committee that was set up and inaugurated on 29 September 2016 by the Chief Director of Ministry of Power.
Who chaired that committee from the beginning?
I'm not too sure who chaired it, but the membership is here.
And Michael Lupa, who started?
I'm not even debating that, but the membership is listed. The full membership is listed. This document, the draft, it talks of original draft. Original draft is draft. And it began from the Mahama administration. Post 2017, they continue to work. The one or two changes, as I said earlier, might have happened.
So the chairmanship changed?
The chairmanship changed because if you look, I'm not going to doubt what he's saying, but the chairmanship definitely changed. I don't know if one or two other members also changed. It may have happened. But they were given 13 PPAs. The committee categorized them into two sections.
13, 1, 3.
13.
Okay. 1, 3.
13. Group A, committed projects. These are projects with executed PPAs and which are either ready to commence commercial operations, under construction, or have reached financial close. Most of these projects have obtained Ghana government guarantee and are in the process of replacing them with PCO. They are in the the initial stage. I'm sorry.
No, that's okay.
Yeah, the other one is put call option agreement. Let me be honest, I don't understand what that means. The other one is government consent and support agreement. So they categorize them into two.
Right.
The second group is candidate projects. These are projects with executed PPAs, but requisite condition precedents are yet to be fulfilled or waived by the ECG or the IPP. Okay? This one that has brought the judgment debt is the GPGC Limited. The Attorney General's advice is here. I will read some relevant portions. It says this agreement was executed on 3rd June 2015 for a term of 4 years, starting from an original commercial operation date of 2018. The buyer proposes to terminate. Those are not necessary. It says this is an emergency power purchase agreement. The total cost of this project, if implemented, will result in an estimated cost of $115 million US dollars, with its attendant high tariff. This is what they are saying. The production and supply of energy in Ghana is subject to the following.
If I could interrupt you just a minute. The agreement approved by Parliament does not support the view of the AG on the high tariffs.
Well, I haven't seen the agreement that was approved by the...
It's here.
I haven't seen it. That's the point I'm making. I haven't seen it. I'm telling you the AG's advice, which was submitted to Cabinet, and on basis of which eventually she advised that the termination should occur. That's what I'm telling you.
Of all the...
Now, Randy.
Yes, go on.
License. Section 11 of the Energy Commission Act 1997, Act 541, provides that except as expressly exempted under this Act, a person shall not, unless authorized to do so by a license granted under this Act, engage in the business or commercial activity for the transmission, wholesale supply, distribution or sale of electricity or natural gas. Enquiries at the Energy Commission revealed that to date, meaning 27th August 2017, to date, the seller has not obtained a license from the Commission. The seller therefore had no capacity to enter into a PPA. Accordingly, the purported PPA is null and void for want of capacity. This is the AG's advice. Permit B. By an established policy of the Energy Commission, a party is required to acquire sitting and construction permits from the Commission before it can begin construction and installation of a plant for the production and supply of energy. Although the seller has commenced construction on site, enquiries from the Energy Commission revealed that the seller has not obtained the requisite siting and construction permits. The seller's construction activities are accordingly illegal. It's a long thing. We can't waste time reading everything. The summary, it says, in light of the above, it is advised that the buyer has right to lawfully terminate the agreement on the following grounds.
The buyer being Ghana government.
Yes. A. Illegality for want of capacity of the seller to enter into a PPA. B. Failure to obtain siting and construction permits. C. Installation of used plant contrary to policy. D. Failure on the part of the seller to fulfill its condition precedents and condition subsequent. That Attorney General was minded. He said, should the buyer tempt so he advised Cabinet that they should terminate.
Okay, from what you read, it appears that the Ejaku letter terminating captures all this.
Yes.
The letter.
Yes, but that didn't constitute termination. By itself, the government had to take action based on AG's advice before.
No,
so it was the Ejaku letter which was termination.
The point I'm making is that it appears that the letter from the Ministry of Energy to the company terminating the contract captures the advice of the AG.
Yes. So the AG agreed with that.
So that's the point I'm making.
Yes.
So that the letter captures it.
So Doc, if we can settle the
just
issue.
Hold on. But have you seen the document from the arbitration panel?
Arbitral award.
Have you seen the award?
I got it last night. I brought it here.
Okay.
Yeah.
Now, so maybe from last night would have been too early for you to
but
finish.
Randy, you go to
it.
court with a defense.
No, I'm just, what I want to ask is, I was going to ask whether you've seen the portion that deals with
these claims.
Testimony, first of all, the testimony of, is it Dr. Hinkra?
Yes.
Dr. Hinkra, who's one is supposed to be the chairman of
this
committee that is supposed to have made the recommendation.
Well, you know what?
Yes.
I'll be surprised if he did.
But have you seen that part?
No.
Check paragraph 490. You have it.
I'll be surprised. Was it contested or not? I don't know.
It was under cross-examination.
Are we suggesting that he had nothing to do with this?
No.
Report?
I'm just saying
he doesn't recollect recommending for the GP.
Sammy, just hold on.
Just hold on.
Just hold on a minute. Just hold on a minute. What Sammy read suggests that Dr. Hinkra, who's supposed to be the chairman of the committee that made the recommendation for the termination, says that he does not recollect. That's one. And two,
recollect.
Yes, he doesn't recollect.
Yes, he doesn't recollect.
First of all, this is somebody.
Recollect doesn't mean he didn't do it.
No,
and he distanced himself.
Just hold on. I'm saying that. This is a person who chairs a committee.
This may be involved from
that produces this report.
May involve a collusion.
He is made aware of an arbitration case. He is invited to come before the arbitration, I'm sure, to support government's case. He's fully aware of why he is going before the panel. And it's about a report that he chaired. A report,
and the case is also about
that
GPGC.
he chaired.
Yes.
And he says that he does not recollect a recommendation to terminate, and also that he dissociates himself from the AG's advice.
I'm surprised. I need to double check this. This document, he's part and parcel of those who made this document.
Now, what I'm just saying is that if you look at the
whole arbitrary,
that's why I wanted you to check.
Record here. You can check. I've given you the paragraph. You can check in 30 seconds. Paragraph 490. It is there. You are very good when it comes to research into documents. So you check now. But Randy, let me also read to you paragraph 479, which is the decision of the arbitration panel on the AG's advice, which Mr. Bako has rehashed, to show you that all these claims are bogus. They are contrived. Paragraph 490. This is what the arbitration panel said. 479. Whether or not Dr. Hincre's evidence to the tribunal was correct when he testified that none of the information said by the Attorney General to have elicited on inquiry of the Energy Commission was provided directly by the Commission to the Attorney General. So Dr. Hincre said all the things the AG has written in her advice, we didn't provide. The Commission, the Energy Commission or committee, they didn't provide that advice to her or that information to her. Rather, all correspondence had between the Commission and the Ministry of Energy. From all that, it is evident on the record available in this arbitration that the premises upon which the AG's advice was founded did not reflect the true facts. First, as Dr. Hincre was obliged to concede, the board of the Energy Commission, which was the body charged with approving a provisional generation license, had not been reconstituted when the GPGC had submitted its application in July 2017. That remained the case at the time the Attorney General was preparing her advice. Second, GPGC did have a building permit from the Blue Ocean for the Blue Ocean site issued by the Pont Catamanso District Assembly. And GOG has not been able to adduce any statute or regulation, including the Energy Commission Act, which addresses the requirement for any additional construction permits. Third, the nature of the GPGC equipment to be used for these works was expressly described in the EPA and had been inspected and approved for use by the ministry in June 2015. Fourth, the extent of the interplay between the obligations of the parties so far as their respective condition precedent and conditions subsequent were concerned has been considered in some. So the arbitration panel considered all the reasons that Attorney General gave for her advice that the EPA should be terminated and said that they are not, these are fallacious claims, baseless claims.
I guess for those who perhaps,
do you understand?
For those who perhaps might not appreciate it, for example, on the issue of the Energy Commission, it says that it is the board that must approve.
Yes.
They put in an application.
2017.
A board has not been
constituted. How is that their fault?
And therefore, it could not have been issued.
Yes.
And the same government that has not constituted a board relies on that thing
to terminate. I've heard something before. And you see, Mr. Baku is doing wonders today that I cannot comprehend.
Which wonders?
Because I know him to be very diligent.
Why?
And to be a stickler of precision when it comes to documents and all that.
Yes.
For the first time, Mr. Baku is referring to a document on Good Morning Ghana, which is not signed.
Oh, which document?
The report you are referring to, this report, a copy of which I also have here, it's not signed.
Is it a fake report?
It is not signed.
Is it fake?
But it is not signed.
This report went to cabinet.
Mr. Bakon, this is basic. A report which is not signed. Can you vouch for the validity of this report?
Yes, I can.
Because I have read to you.
I know where I got it from.
Look, I have read to you, even though it is not signed.
I know where I got it from.
Even though it is not signed, but the person it is attributed to. I have read to you
it's not
paragraph
this thing is
490 of the. Hold on. I've read to you paragraph 490 of the arbitral award, which is like a judgment of a court.
We need to go.
Telling you that the one who is alleged is that a signature? This is a list, not a signature. The one who is alleged to have chaired the committee says that I don't recollect making any such recommendation for that document.
We need to go.
To be terminated.
We need to go.
But why are you
belated happy birthday to you, Angel Kabonu,
It is a sacrilege. It is not
president of NAGRAT, and it's from your vice president and Annie Ampofu from here. And Adja Shifa, belated happy birthday to you as well. Gentlemen, thanks for joining me on the show. Our installed capacity has expired. God willing, will be with you.